So, hello, good evening from my side. We have 5 o'clock here in Central European summertime. We have again a very international audience. And for the ones who know this format, the SAPI IP Business Talks, they know that you are invited to write questions or greetings, but basically questions or comments in our chat, and I will try to pick that up and to talk with Mingo about that. So, and that's my guest today. I'm very happy to have you here, Mingo. Thank you very much for taking the time being with us. We are today in Argentina, or you are with us, or we are with you. It's depending on the perspective. But I see that wonderful light in your face from Argentina. That's great. And Mingo, please explain us a little bit about your background. We talked already about that. It's a fascinating story. Also, your family story with your law firm. So please tell us something about you. And thank you very much for being here.
Well, thanks so much for the invitation. I truly hope that the audience will be happy with the things that we get to discuss today. And in relation to my background, well, I'm an attorney at law. I'm specialized in intellectual property. I've been working at the firm since 1997, so that's quite many years. The firm, as I just was telling you, it used to be a family firm. It was bought by my great-grandfather in 1933. Before 1933, it used to be called Fuchs and Palacio, but since 1933, it has been called Palacio. So it's quite an old firm in Argentina. It's not the oldest firm, but it's amongst the oldest firms in Argentina. And nowadays, we have 26 people working, so no longer a family firm. A lot of people working over there. And I've been the managing partner for the past 2 years, I think. Yes, 2 years. So it's been quite interesting to learn a new phase of the business, to manage the office. It's been quite a challenge. And I have to thank a lot for that to my partners who have been kind enough to pay enough attention to me, but not that much. So it's interesting.
Yeah, I mean, it's a challenge, isn't it? Because
yes, it is.
Typically a lawyer or patent attorneys, they are not educated in management, so they come from their experience, and they come from their education training from the law. And then to run a company, to manage a company, is something completely different.
Yes, I know. That's why 2 years ago, when it was decided I was to manage the company, I entered a couple of master degree courses on management of companies and specialized on family business, though it's not entirely family business. So that has given me a few tools to work with. But still, it's great. It's much easier to manage when you have good people, a good team to manage. It's way easier than to manage something else. So if I'm doing something right, it's because I have a lot of help from my partners.
Okay. Yeah. It's easy to manage the talented guys and the willing guys, of course. I mean, okay. My first question to you is something which we discussed in advance. It's first of all, maybe not everybody in the audience knows that Argentina is a non-PCT country, and what you told me is that also your law firm works a lot with foreign filings from around the globe. And of course, Argentina is also an interesting market, no question about that. And so, can you explain a little bit how that fact that Argentina is a non-PCT member, how that affects the patent filing in general?
Okay. Well, first, yes, we have the award, or the the luck of being one of the few countries that are not a PCT member. I say that in an ironic way, together with Uruguay, Paraguay, Bolivia, I think Venezuela, and a few countries from Africa, and I think Afghanistan and Yemen. And I don't know if I'm leaving any other country outside. So, yes, not being a PCT member, it really creates some complicated scenarios, especially from to our colleagues from other places around the world. I have to say that even though we advise our friends and our colleagues every now and then that they should remember that we are not a PCT members, and they should have a warning or a reminder about every 6 months or so to check with their clients whether any one of them is willing to file in Argentina. They should do it within the Paris Convention priority terms, which is 12 months. We still get emails, I'd say, once a week or once every 2 weeks from colleagues from different parts of the world asking us if we can help them to enter the national phase of a patent application in Argentina. This is when things get complicated sometimes, because you have to call the colleague or send them an email, and let's hope that this was not a very big case for the client in Argentina, because if the patent has already been published somewhere, the novelty has been lost and there's nothing to do around that. If the patent has not been published yet, and of course, if we are still within the 12-month priority term of the Paris Convention, we can still file the application. No problem, we can claim priority. If we are between the 12-month period and the patent has not been published yet, so novelty has not been damaged, we can still file the application without claiming priority. And in most cases, we have a good luck. We have a good amount of cases that have been granted. The patents have been granted. So, but there's a very small window there from when the Paris Convention terms expires until the patent is published somewhere in the world. And in those cases, after the patent application has been published, novelty has been destroyed, and there's nothing you can do about it. So,
yeah. I mean, that's really a timing issue, isn't it?
It is.
Yeah. Okay, got you. And just to talk about that in addition, so how is it? So I mean, when I file a patent in Argentina, at the end, I have the intention to get exclusivity for my product, for my technology. And how is your enforcement? Is that because what I learned is that in Brazil, the companies, for example, are quite reluctant to work with IP, and that it is not that easy to enforce. So how is it in Argentina? What would you say as a general, let's say, recommendation and experience?
Well, in my experience, if I have to summarize all different cases from different fields of innovation, I have to say that it's assorted flavors. Depends on the kind of patents that we're talking about. It depends on the kind of structure that you need to carry on with that procedure or to manufacture that product or the kind of product. There are some cases in which enforcing a patent has proved to be troublesome, that you run into a lot of difficulties, either to find the person who is producing or manufacturing the goods, the counterfeit goods, or who is. But in some other cases, when the production of the goods needs an important facility, needs a lot of capital to be invested, it's easier to get enforcement. That's on the big scenario. Now it also varies on the field of the innovation. Mm-hmm. Here in Argentina, the policy, the government policy is to provide a lot of protection to local labs. So, as we will probably discuss later, patent granting for pharmaceutical products is very difficult. There are a lot of obstacles to obtain such patents, and then to enforce a patent, to obtain an injunction. There's an article of the law that states that before granting an injunction, the judge must ask an expert witness to determine whether, if the patent would be challenged, patent would survive that challenge.
Okay, the nullity suit.
Basically, after many years of discussing with the patent authorities at the patent office whether your product or your process to manufacture something is patentable or not, when you have to enforce it, you have to go to a judge. The judge will ask an expert witness to determine whether the patent has been granted correctly or not. So it's reviewing the whole proceeding again. That is
how long does that take?
Depends on the field also. If we're talking about pharma, it may take 2 or 3 years to have an injunction or to start which is basically telling you that you will not be able to enforce it. On other fields of innovations, it will take 3 months, 4 months. Depends on the obviousness of the case. It depends on the complexity of the case. But I can tell you that we have obtained injunctions. Clients of us have received injunctions from other parties in mechanical patents, in manufacturing of other goods. So other than pharma, it works not as good as it would work in Europe or other places, but it still works pretty good. It takes some time, but in the end, you get the results. Pharma, it's a completely different question. It's a completely different scenario. It's politics are involved and something totally different. I don't know if you want to get into that scenario just now or not.
Okay. Thank you for that overview. I mean, it's always asking such a generic question, and then I know it's difficult to give generic answers. And thanks for giving us an overview in a few minutes. So what we would like to talk about is an important issue is technology transfer. Okay. And we had last week we had a talk about technology transfer for Latin America in general. That was quite interesting. And so when we focus on Argentina and the technology transfer situation, so is there any specific tax regime in your country which can help, for example, for licensing trademarks or patents or something like that? So some IP?
Yes, there is. Actually, the technology transfer law in Argentina allows for the registration of contracts, not only transferring technology between a local party who receives the technology and a foreign party who provides such technology, but also the law states that you can also register the licensing of trademarks and patents at the same office. And this provides, depending on the kind of technology that you transfer, or whether it's a trademark license agreement or a patent license agreement, you have different tax breaks on the income tax, both from the local party and the foreign party when they have to transfer the money abroad. Also, in the past few years, I don't know if you have been following the politics situation in Argentina, we are facing a lot of restrictions to send money abroad, to have access to foreign currencies. So this affects every aspect of the Argentinian commerce every day, from colleagues transferring money to other colleagues in different countries. I know that this is an issue for an audience. Perhaps they received some work from an Argentinian firm and they are having troubles to pay the bills. it's because of these restrictions that we are facing. If you have your trademark, patent, or technology transfer contract duly registered before the direction of transfer of technology, then you have a easier way, you have a simplified way to get into to obtain the foreign currency to pay to send it abroad, to wire that money to other countries. But still, nowadays we are facing a lot of difficulties in this area. And for example, when the contract of transfer of technology is signed between related parties, then I think it's 3 weeks ago, a new resolution from the central bank stated that a report from English is not my first tongue.
No, don't worry. Me too.
I get lost. Transfer prices, that's the word, sorry. You need a report from transfer pricing to state that the prices that you're paying for such a technology are reasonable for and that you are not just wiring money abroad to take it out of the country. This would also...
excuse me, Mingo. We have that regulation also from the OECD.
Yes.
That when you have two companies which are not really third parties, then always the danger is that you shift profits from one country to another country, and then we have that OECD regulations about transfer pricing, and quite often it is done. So this profit shift. I mean, we have Apple, we have IKEA, we have many well-known companies which are using also very let's say tax-friendly regimes, like here in Europe, in Ireland or so, or you go anywhere on a tax haven in the on the Bermudas or anywhere, and companies try to avoid then to reduce the global tax based on such IP holdings. I mean that's a big this tax base erosion, how it is called, is a big issue around the globe for every country, I guess.
Yes, I know. Before until a couple of months, let's say until at least a year ago, you still have this regulation to check with the transfer pricing. But you wouldn't need to have your contract registered before the transfer of technology in order to transfer money, to wire money over this for transfer technology, to license trademarks or patent licensing. Nowadays, if you don't have the contract duly registered, it will be almost impossible to obtain the authorization to wire that money. It's not that obtaining the authorization is easier. It's still complicated because in Argentina the government is running out of money, and they're trying to protect everything that they have.
For example, they start to become creative to collect money.
Yeah, exactly. For example, one of the new requisites that you have is that in order to access the foreign currency market to make the wire, you have to prove, or you have to provide a sworn affidavit that you don't have any bank accounts in foreign countries, and if you do have such an account, your balance is zero. Because if you have money abroad, the local government requires you to use that money prior to give you access, to grant you access to the foreign exchange market here.
Yeah, got you.
What's the big deal that is going nowadays? We have two different values for the US dollar, for the euro. The official value for the dollar in Argentina is around 100 pesos, but very few people can access to that currency exchange. If you want to go to the informal market to obtain the dollars, you have to pay 170 pesos. So that's a 70% difference, and that can turn a business from profit to bankruptcy.
So, of course.
Proper analysis of a business prior to trying to send the money abroad is totally relevant. It's the difference between staying alive or going below. So that's the main issue nowadays with transfer of technology. A lot of companies have are nowadays filing their contracts, which they didn't used to do a lot, but they're nowadays trying to draft their contracts of licensing trademarks, licensing patents, to check every file whether they can obtain a tax break or not, or whether they can access to send money abroad at a much more reasonable exchange rate. So
okay.
a lot of movement in that area around
So
that
what
now.
you say, when I got it right, is what you say is that this specific currency issue rises really a market of technology transfer, because it is a way to get foreign currencies.
Exactly. It does not guarantee that you will access, but it raises your chances a lot. It'll give you
It's
much more.
fascinating.
It's creative, as you said a few minutes ago. They build
Yeah,
new one.
as I think we have to be creative.
Exactly. That's why
Yeah,
I love it.
I mean, we have the story from Marshall Phelps at IBM, that he, in the 80s, that he started to an infringement enforcement program for IBM, and solved the money scarcity of IBM by this enforcement program, and realized, I don't know, 1.5 billion for IBM out of enforcing infringed patents for the Big Blue. And that was quite new and very creative to generate money out of IP. And or what we see, let's say, with Philips, which Philips is creating use cases around the usage of light, because they have the problem that light bulbs are not a business anymore. So now we have LEDs, and LEDs have a infinite lifetime. And so we have a wonderful case study about that on IP strategies in the IP Business Academy. And what Philips is doing now, they create use cases around the usage of light. They patent it, and then you can get from Philips the hardware, the software, and the patent license. And the Enable LED program has already, I don't know, more than 1,000 licensees around the globe. So again, a very creative, let's say, usage of IP, and this is exactly what we see here in Argentina.
To create new business and to make profit of your investment. After all, your IP is an investment. They are assets, and the more ways you find to obtain profit from them, the better.
Yeah. Do you think that this very specific situation of Argentina here, in that case, that rises the propensity, the activity in filing trademarks and filing patents in Argentina? Because at the end, it gives you more opportunities.
I think it does. It raises the awareness of the importance of having all your IP assets duly protected and to make the most of them. After all, they are tools to protect your developments, your business, and the smart and the many smart ways you find to use them, to protect them, and to obtain profit from them. It generates awareness of for companies of the importance of IP. Therefore,
yeah, that it is let's say here it is a kind of financial instrument.
yes.
So we see in China, for example, that companies get an incentive for filing patents, and also there, and you get easier access, for example, to financial solutions once you have patents. We have here in Europe a very specific program from the European Investment Bank, which is supporting loans based on IP.
You said yes. Here in Argentina, the use of IP as collateral has something that was not very heard of in the past, but in the last 2 years we have many consults from different clients, whether they can use their IP to put as collateral for to obtain, I don't know, loans or whatever, and it's something that's growing. It's growing in the awareness of companies. A lot of companies, a lot of managers never thought of using IP as collateral.
Yeah, of course.
Take it. Nowadays, they see that they have an asset, that asset is valuable, and as any valuable asset, it can be used as posted as collateral. And they all these new ways to use your IP assets, it brings awareness, and with awareness comes more focus on IP, more companies checking whether they have all the IP duly protected, whether they have everything in order or not. So that's something.
That's really fascinating to learn that from Argentina. That in Argentina is really there, rising of awareness on the financial instrument IP. That's very, very interesting. So, if you are interested to write a blog post on that, I would be happy to publish it, because that's very, very interesting to see that that because of their certain need, of assets. Then you go to the intangible assets and use them here in such a creative way. It is said that need makes creative, and we have here exactly the situation that's great.
It is.
Okay, so and another question is, we saw a change in the trademark law in 2018. Could you explain that a little bit, this change, and how that change in the law changed also then consecutively the trademark strategies of the companies?
Well, until 2018, Argentina used to have a very unique system, both in the way to solve oppositions and in the way that partial cancellation of trademarks was not allowed. If you had a trademark granted in for example, let's say I used to manufacture clothing, and I had also a trademark registered in class 4 for oils and stuff, the use of the trademark in class 25 would be sufficient to repel any cancellation action due to lack of use in class 4. So that would allow companies to obtain defensive trademarks in all the 45 classes.
Yeah, it blocks a lot of usage.
Blocks a lot of usage. That, and the fact that before 2018, oppositions were solved not by the trademark office, but by only before a court of law. So that involved a very long and expensive procedure with a fully open, fully evidence disclosure, long lawsuit, really expensive. And in many cases, those kind of lawsuits were difficult to be justified. Things could have been solved by the trademark office. Whether this trademark is confusingly similar to the other trademark, it's not something very difficult. Some other cases which involve bad faith registrations or other things other than comparing trademarks, perhaps would be more reasonable to be treated before a court of law, but that's it. So in January 2018, we woke up one day with the presidential decree, which was called Debureaucratization and Simplification of the Law, which included things as related as civil aviation, mining, trademarks, patents, and agricultural contracts. It was like 140 pages long. It changed everything, almost everything, electronic signature, everything. So it really brought, it moved the Argentinian loss scenario 20 years forward, changed a lot of things. But a lot of changes require a lot of thought. and it also brought a lot of chaos. A lot of details were not contemplated. Actually, the change started in 2018, and we have only had the first ruling of oppositions by the trademark office in late December 2020, and some of them are still the time for filing an appeal before the Federal Chamber of Appeals is still open. So we are still learning all the details of this new system.
Wow.
The basic change is that in the past,
and there was not a hearing before in the process of making that.
Not even a warning. Well, there have been little warnings, little
Rumors
here and there, but rumors, but nothing official. So actually, I don't know if I have time for a small anecdote here.
Yes, please.
My brother, my partner, woke up in the morning, read the news about this, and he sends an email about 6:30. He wakes up really early, saying they've changed the law, they've changed everything. We had an emergency meeting at the office at 8. We saw the first I don't know
Publication.
The first publication. We drafted a small bulletin and we sent that bulletin to our clients. At 11 a.m. I received a call from a colleague from another firm saying me, "What is this nonsense that you're talking about? Nothing has changed." They say, "Have you read the official bulletin today?" "No, let me see." And half an hour later he called and said, "Sorry, you're right. This is crazy." No, it was nobody heard any warning. So well, back to.
But I mean, that just to stay a little bit on that issue. I mean, from a governmental perspective, I want to avoid confuseness. So I mean, I understand that they want to change something, of course, and typically the argumentation is we make it better, but it makes a lot of sense to have hearings from the experts to explain. I mean, we had a situation here in Germany. And so Germany is not famous for being quite agile, and fast. So we are not. And we have the tendency to think all the things 1,000 times through before we act. So we are afraid of acting to a certain extent because that might involve risks or mistakes. And what the government did is that in these Corona times, I mean, lots of governance went nuts during. So you really were able to see how they think, when during Corona,
Yes,
and we had a regulation which said that we skip a working day. Okay, so we make a working day to a public holiday, and then after the next 12 hours, the whole economy, the whole industry went nuts because of switching from a working day to a public holiday within 1 week. So it's nearly impossible. So you have logistics, you have tax, you have accounting, you have to pay them. So it started that.
Software.
It was the feeling that the government has no idea what's going on out there in that country. And to a little bit is that what you're saying. I mean, it's much bigger what you're saying there, right?
This was published in 2018 in January. In 2019, they started issuing the first regulations on how the opposition system would actually work. You know, you have the law, and then you have all the regulations which state what you have to file, where, and everything. And I had a discussion with the head of the trademark department, and I told him, I made him this little story. It's like I'm playing a football match, and you haven't decided what's going on. What will happen if we tie? And I have to define my strategy. Will we have an extra time? Will we have an overtime? We'll go straight to penalties. I need to know what's going to happen, because on what's going to happen, I will decide whether I change goalie or change who's going to.
Yeah, of course.
You can have me playing the match, and after the match, tell me, okay, now we'll go for overtime or we'll go to penalties. Well, this is what happened here. They changed the law, and they say, okay, we will see how things develop, and we will try to order things. We'll
Yeah,
still
you cannot prepare. You cannot prepare. You cannot make a strategies. Nothing. You just have to take the law how it is and
Well,
give the best possible advice. But it's crazy. Yeah.
crazy. It's definitely crazy. Well, the same thing happened with cancellations and of trims due to lack of use or mistakes or prohibitions during registrations. There are some parts.
Is there? Excuse me, Mingo. One question:
Yes.
Is there? I mean, it's 3 years ago. I guess there was a lot of discussion about that. And what was the intention to act in that way from the government?
The government stated that they thought that for trademark owners going through a long lawsuit, which would take 7 years to find whether the trademark would be registered or not, was something that attempted to a business-minded company. And probably after 7 years of litigation, perhaps the product was not even in the market anymore. They would have lost interest. So they tried to move to something much more agile. And actually, what goes, they tried to use the system that is widely used all around the globe, which is that the trademark office will decide on oppositions. Basically, say we are on one side of the world, the rest of the world is on the other side. Let's do what the world is doing, which, generally speaking, is not bad. But as you said,
Yeah. It's not the procedure. It's not the intention. The procedure is strange.
When you change something, you have to think the whole change and how will that affect everything. You cannot say, okay, now you decide this. Say, well, you have to give me people, you have to give me budget, you have to give me offices, you have to give me a system, we have to prepare a lot of how are we going to deal with this. We don't have the powers that the judicial system has. How are we going to ask for, I don't know, to a company to provide their books, the accounting books? If a judge orders you to give the books, you give the books. But if a trademark office, a clerk from the trademark office asks you to give the books, there's no law that requires you to open your books in that case. So there are a lot of things that had to be considered and prepared and everything. That's why it took them almost 2 years to finally start with solving oppositions. The first thing that happened was that during almost a year and a half, almost 2 years, people were lodging oppositions, and they were piling up until somebody decided what to do with them. Nowadays, they're trying to reduce the backlog, which means that in some weeks we are receiving around 1,500 opposition notifications, which is chaos. It's like, okay, we're trying to reduce the backlog, and everybody has to run to meet the deadlines.
It's a flood.
Exactly, it's a work flood that you have to deal with, but it's interesting. And basically, the one thing that changed, going to the strategy that we were discussing, the change from not accepting partial cancellations to accepting partial cancellation has been, I think that in the long term will be one of the biggest changes, because in the opposition decision, once things get settled, we will always remember the time when this was chaos, but we will get used to. It's just change who decides. But with the partial cancellations, it completely changes the scenario. It will take a few years to people to get used to this new tool, but it will definitely change the strategy that companies have to use to protect their trademarks in Argentina. because
could you give us a little bit an example how companies behave now, and or could you give a recommendation how companies should behave according to the new regime?
For example, you know that there are trademark. Well, at least when I have to advise my clients, I tell them that there are 3 circles of protection. At least there were 3 circles of protections in Argentina, which was the first circle, that the most basic need that you have is to protect with trademarks the products or the services that you produce or provide. Then the second circle will be those services or products that even though you do not provide or you do not produce, you think that if someone else produces or they try to sell them with similar trademarks, it will harm your business. And then it's the second circle. And then there was the third circle, which is okay, if you have enough budget, you can just file for as many trademarks as you want. That third circle has been removed now, because if with the partial cancellation, that protection will only last you for 5 years and then you're exposed. So the also in the second circle, if the products are not so related, you might be getting into a gray area whether the trademark office will decide if those products are related enough or not. That's something you have to take care of. So my advice obviously would depend on the case by case, on the budget, or
of course,
exactly. But it would be to pay much more attention to find those specific markets where you think that a third party may profit if you are not there, and try to obtain protection over there. Perhaps not the exactly same brand, but a different logo, and you go changing the logos or your devices every 2 or 3 years to file those differences. So in order to have different trademarks, not all of them will be exposed at the same time. So you try to obtain different protection. But this, as you can imagine, it has to be the advice has to be provided on a case by case, and see where the client has the itch, to see how we scratch it. No, it's like.
So how have your clients reacted to that? I mean, they had to adapt their strategies. They had to rethink. I mean, companies have portfolios. They have a certain strategy behind that, and that had to be adapted fully according to that law. So I guess that was quite a challenge.
It was quite a challenge. It also meant a lot of work, which is something good always, and it has also provided a lot of opportunities to contact and to work together with clients, which is also always a good thing. But yes, it meant that we had to call our colleagues, our clients, and tell them that we had to rethink everything, that we have to see whether the protection that we had designed previously will be sufficient for the next few years. So as usual, obviously it changes from client to client, no? But it meant a lot of work.
Yeah, I guess so. But on the other hand, it's a good, as you said. I mean, at the end, every kind of change in law gives at the end the opportunity to redefine strategies, to find new answers, and sometimes even to overcome behaviors which are not perfect, but they are, let's say, the tradition. We do it in that way. And when then comes a new legislation, we can. I mean, we have that here with the digital transformation, and companies start to rethink the whole strategy, and they end up with understanding, with getting an understanding that the old strategy has no future, and this is not just because of digital transformation. It is because the old strategy was an old strategy. And so it's a good thing having that impulse, that outside shock to rethink the things.
Yeah, well, at least on our side, one thing that I'm really proud of is that we don't panic with changes. We see them as challenge. We love this kind of challenge and to rethink, to be able to reconsider things and to analyze them from a new perspective. And after all, if things don't ever change, you'll never get new results. So
Absolutely.
I'm not afraid of change. Sometimes I would wish that change would have a little more thought beforehand, as you mentioned. But once the change has been decided and it's been enforced, you need to be able to adapt. You need to be able to adapt quickly. Hopefully that's something that we are really proud that we are doing good. So
we call that in theory, in economic theory, we call that dynamic capabilities.
Exactly. Well,
okay, Mingo, thank you very much. The time is over for today. Some questions are left, so we should meet again to talk a little bit more about the quite specific situation in Argentina. So thank you very much for taking the time. Thank you to the audience. Mingo, it would be great when you take the time for our after show party on LinkedIn. So typically we get questions, and so it would be perfect to have you there always, also a little bit for being available for questions. Okay, thank you very much to Argentina. Bye-bye.
Bye-bye.
Bye.